Hey, it's Eli Sluter with Sluter Law Firm. You may recall that I am licensed in Arizona, New Jersey, and Pennsylvania, but remember that these classes are not state specific, so the terminology might be different in your class. Today I want to talk about the basic estate planning documents. These are the 4 documents that make up a basic estate plan. Okay, there's 2 different kinds of wills and 2 different types of powers of attorney. 2 of these documents deal with your finances, and 2 of them deal with your health care or your medical treatment. Most people, when I talk to them about estate planning, this is kind of what they look like, right? They are very confused. They say, oh, uh, what is a will? What is a last will and testament? What is a living will? And what is a living trust, right? There's too many wills, too many livings. It's very easy to get confused by the terminology, and I hope that this is going to help clarify that for you. We're not going to cover living trusts in this class. That's going to be a different class that's coming soon. Real quick, this is information only, not legal advice. Watching this video is not going to make you my client. It's not going to make me your attorney. This is advertising material, not been approved by any court or bar of any state. Okay, we've determined that there are too many wills. How many wills are there? There are too many. Okay, there are 2 types of wills in your estate plan, and both are expressions of your free will, which is your ability to act in your own discretion. Your last will and testament deals with assets and finances. It is literally the last expression of your free will. That's why it's your last will. Your final written testimony, that's where we get the and testament, regarding who gets what when you pass. When is it effective? It's not effective until you pass away. Compare that to the living will, which deals with your medical treatment. It is only effective when you are nearly dead, as opposed to the last will being effective when you're dead. It is enforceable only in these following circumstances. All of these have to be true. You're very near the end of your life and suffering from an incurable and irreversible condition. It's making you miserable some way. You have a diminished quality of life. It is terminal, meaning the doctors expect that you probably won't survive more than 6 months or so, and you require some sort of life-sustaining treatment, whether it's breathing machine, heart machine, feeding tube, something like that. All those have to be true, and you have to be unable to make or communicate decisions on your own. Okay, you can't blink once for yes, twice for no. You don't have a bell like the guy on Breaking Bad. Okay, next we're going to talk about POAs. POA stands for Power of Attorney. This document appoints someone as your agent to make decisions and or act on your behalf. Okay, how many powers of attorney are there in your estate plan? Again, there are 2. Too many. The first one we're going to discuss is your durable power of attorney. This covers your assets and your finances. Okay, why is it called durable? Because it is strong enough to survive your incapacitation. A normal power of attorney would expire if you became incapacitated. For instance, if you gave me a limited normal power of attorney to sign the closing docs at the closing for the sale of your property, real estate property, and then you got hit by a bus before I was able to get to the closing and were in a coma, I would no longer have the authority to sign on your behalf, okay, because it's not a durable power of attorney. When is it effective? It can be effective immediately. With your spouse, perhaps you want your spouse to be able to sign and do things on your behalf right away without you having to be incapacitated first, or if it's your alternate agent, maybe a sibling or something like that, you would not want them to be able to go and sign documents, legal documents, and handle your assets and finances unless and until you became incapacitated. The next document we're going to discuss is the healthcare power of attorney. This covers your medical treatment. By its nature, your healthcare power of attorney is durable, right? It's only effective when you're incapacitated and unable to make and communicate decisions on your own. Okay. Your healthcare agent that you appoint can override your living will. So it's important that you discuss your wishes with the healthcare agent that you're naming your primary and your alternates, so they have an idea of exactly when you would want your living will and how you would want your living will to be enforced. Okay. So just to review, we had the two different types of wills and two types of power of attorney. Okay. Here's a little matrix that kind of will hopefully illustrate the different types of document, the two different types of wills, two different types of power of attorney, and what they govern. Okay. The living will and the healthcare power of attorney, the two medical documents, are often combined. That document is often called a combined advance directive for healthcare or advanced healthcare directive. So there you go. Those are the documents that make up your basic estate plan. Give us a call or set up an appointment today, and we can help you get the peace of mind that comes from knowing that you have your affairs in order. Thank you.